I thought so, my lord. My lord, volume Roman 5, 29.
From Allahabad, there is nothing there. Meaning 11,670 पेज खोलिए.
My lord, can I give my copy for immediate reference? My lord?
यानी मिल गए.
State of Punjab governor.
No, like, yes, go to
My lord, 11669,
paragraph 16.
paragraph 16. My lord, I'm grateful. My lord, where
Shamsher Singh.
Shamsher Singh is noted, para 28 and 32 are quoted, my lord, which I read. May I reread it, my lords? Or may I my lord, read them again?
Yes.
Yes. Under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on aid and advice of his council of ministers, save in spheres where governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of the sovereign is considered by the practical rule that the crown must find advisors to bear responsibility for his action. Those advisors must have confidence of the House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. These two paras are quoted. What is missed from Shamsher Singh is in my written submission at page 197. Lord, these two paragraphs. Your lordships are at page.
Other than those two paragraphs, nothing else is referred of Shamsher Singh.
And this is what I'm now showing.
54 and 55 you want to.
And it's a Shamsher Singh is 7.
66.
Well, please see para 54 and 56. The provisions of the Constitution, your lordship gets one. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. The other articles which speak of discretion of the governor are para so-and-so, para so-and-so, so-and-so 6th schedule, and article so-and-so, so-and-so. The discretion conferred on the governor means that as the constitutional or formal head of the state, the power is vested in him. In this connection, reference may be made to Article 356, which states that the governor can send a report to the president that a situation has arisen in which the government of the state cannot be carried on in accordance with provisions of the Constitution. Again, Article 200 requires the governor to reserve for consideration any bill which, in his opinion, if it became law, would so derogate from the powers of the High Court as to endanger the position which the High Court is designed to fulfill under the Constitution. Now, 55. In making a report under Article 356, the governor will be justified in exercising his discretion, even against the aid and advice of the Council of Ministers. The reason is that the failure of constitutional machinery may be because of the conduct of the Council of Ministers. This discretionary power is given to the governor to enable him to report to the president, who, however, must act on the aid and advice of Council of Ministers of the center in all matters. In this context, Article 163(2) is explicable that the decision of the governor in his discretion shall be final and the validity shall not be called in question. The action taken by the president on such a report is a different matter. The president acts on aid and advice of Council of Ministers. In other matters where the governor acts in his discretion, he will act in harmony with his Council of Ministers. The Constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of Council of Ministers. Now, please see 56 is important. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from the Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. My lord, now I'll come to that, my lord, and my learned friend also will take assist your lordships on that. My lord, in the judgment of Tamil Nadu, this is my lord, distinguished by the honorable two-judge bench, my lord, relying upon a concurring opinion in this seven-judge bench judgment, my lord. One paragraph of the concurring judgment. I'll come to that. Now, my lord, next judgment is MP Special Police Establishment Act. Again, my lord, 5 judges and was not noticed by the state of Punjab judgment. Now, para 11, I'll skip, my lord, the first part. First part gives the facts. What were the facts of that case, my lord, which may not be relevant for the present, but I have put it, my lord, for ready reference. Para 11. Mr. Sorabji submits that even though normally the governor acts on the aid and advice of Council of Ministers, by or under the Constitution required to exercise his functions or any of them in his discretion. The Constitution of India expressly provides for contingencies, my lord, so-and-so, so-and-so, so-and-so. However, merely because the Constitution of India expressly provides, in some cases, for the governor to act in his discretion, can it be inferred that the governor can so only where the Constitution expressly so provides? If that were so, then subclause 2 of Article 163 would be redundant. A question whether a matter is or is not a matter in which the governor is required to act in his discretion can only arise in cases where the Constitution has not expressly provided that the governor can act in his discretion. Such a question cannot arise in respect of matters where Constitution expressly provides that the governor is to act in his discretion. Article 163(2) therefore postulates that there can be matters where the governor can act in his discretion even though the Constitution has not expressly so provided. Mr. Sorabji relies on the Shamsher Singh versus State of Punjab. A 7-judge bench of this court inter alia considered whether the governor could act by personally applying his mind and or whether under all circumstances he must act only on the aid and advice of councillors ministers. It was inter alia held as follows. My lord, para 54 to 56.
Which you just read.
Which I just read, which my lord appears to have escaped the attention of the bench in state of Punjab. Now, my lord, again, MP judgment again starts. Thus, as rightly pointed out by Mr. Sorabji, a 7-judge bench of this court has already held that the normal rule is that the governor acts on the aid and advice of Council of Ministers and not independently or contrary to it. But there are exceptions under which the governor can act in his own discretion. Some of the exceptions are as set out here in above. It is, however, clarified that the exceptions mentioned in the judgment are not exhaustive. It is also recognized that the concept of governor acting in his discretion or exercising independent judgment is not alien to the Constitution. It is recognized that there may be situations where, by reason of peril to democracy or democratic principles, an action may be compelled which from its very nature not amenable to ministerial advice. Such a situation may be where bias is inherent and or manifest in the advice of the Council of Ministers. My lord, this judgment of MP, 5-judge bench, my lord, is, my lord, not considered, my lord. It has escaped the attention. Now I come to, my lord, most important judgment, Nabam Rebia, a relatively recent judgment, my lord, Arunachal Pradesh, my lord, issue. My lord, I must say, this is again, my lord, my lord, it has escaped the attention of the bench in state of Punjab. It was placed for consideration in Tamil Nadu judgment, my lord, but it quotes some paragraphs, Tamil Nadu judgment, but para which I am going to read, my lord, again has missed the attention of the bench, my lord. Kindly see, my lord. Similarly, in Nabam Rebia, para 151, 152, the Honorable Court referred to the Punchi Commission's formulation that governor's discretionary powers include to give assent or withhold or refer a bill for presidential assent under Article 200 and expressly endorse and adopt it. It was held as under. But 151, the important observation in Justice M.M. Punchi Commission report with reference to Article 163(2) are contained in para 4.5. The relevant extract in the extract of the same is as under. Article 163(2) gives an impression that the governor has a wide, undefined area of discretionary powers even outside situations where the Constitution has expressly provided for it. Such an impression needs to be dispelled. The Commission is of the view that the scope of discretionary powers under Article 163(2) has to be narrowly construed, effectively dispelling the apprehension, if any, that the so-called discretionary powers extends to all the functions that the governor is empowered under the Constitution. Article 163 does not give the governor a general discretionary power to act against or without the advice of his Council of Ministers. In fact, the area for exercise of discretion is limited, and even in his limited area, his choice of action should not appear to be arbitrary or fanciful. It must be a choice dictated by reason, activated by good faith, and tempered by caution. The governor's discretionary power are the following: to give assent, this is Punchi Commission. The governor's discretionary powers are the following: to give assent or withhold or refer a bill for presidential assent under Article 200, the appointment of chief minister under Article 164, dismissal of government which has lost confidence but refuses to quit since the so-and-so, so-and-so, so-and-so. Now, my lord, Nabam Rebia, 5-judge bench again, my lord, quotes with approval this observations and says, we are of the considered view that the inferences drawn in the judgment MC Punchi Commission report extracted herein above are in consonance with the scheme of the functions and powers assigned to the governor with reference to the executive and legislative functioning of the state, and more particularly with reference to the interpretation of Article 163. We endorse and adopt the same as a correct expression of constitutional interpretation with reference to the issue under consideration. My lord, if your lordships were to see, my lord, how this is dealt with in Tamil Nadu, volume 31, my lords. This is 151, 152. Lord, this Nabam Rebia is missed in Punjab judgment. Tamil Nadu judgment takes note of it. But please see, my lord, so far as these two paragraphs are concerned, my lord, that again has missed the attention of the bench, my lord, in Tamil Nadu, my lords.
Which para?
My lord, page 12432, para 301. The lordship gets, my lord.
Yes.
11301. Lord, another constitution bench of this court in Nabam Rebia had the occasion, my lord. Thereafter,
One page number?
I'm sorry, 12432.
Yes. Paragraph
12432.
Yes.
Para 301. Another constitution bench of this court in Nabam Rebia. Nabam Rebia is, my lord, taken note of. Then, my lord, the honorable court is pleased to quote 140, para 147.1, 147.2, 148, 149, and at page 12435, Lord, possibly misses 151 and 152, which I read, and comes to 154. And this discussion in Tamil Nadu is directly while dealing with the question of discretion. These two paragraphs, my lord, since, my lord, it escaped the attention of the two-judge bench, my lord, I am placing for your lordship's consideration. Now, my lord, I come to the next judgment, that is B.K. Pavitra. But this is two-judge bench judgment, which is declared.
Just 1 minute. Come back to page 12432. The Tamil Nadu judgment refers to paragraphs 147, 148, 149, and then it jumps to paragraph 154. 151 and 152 are left out.
That's what I submitted, my lord, with profound respect. That two paragraphs seems to have escaped the attention of the bench, my lord. Because from 149, it directly goes to 154. And in my submission, the real law is laid down in 151 and 152. And this is, my lord, while discussing discretion, the point which I am arguing, my lord, whether in all cases aid and advice is binding or there is a room for discretion.
Yes.
Lord, now please come to page 200 of my submissions, my lord. B.K. Pavitra judgment. Lord, this issue was squarely there.
Can you
This-
read the 154 with Tamil Nadu refers to underline
Only a
which comes after 152. They same very page. 154 of Tamil Nadu follows 151 and 152.
Please contain the two other
Lord,
paragraphs are
154 is Nabam.
वो दो missing.
In चार paragraph.
बाद में
151 and 150.
Lord, 154 is slightly different from 151, 150. It is not slightly, but not substantially. Lord, now kindly come to B.K. Pavitra. Page 200. This is, of course, a two-judge bench judgment, but it is declared per incurium. And I'm not repeating the argument, my lord, but this itself was sufficient enough for a reference under 145.3. Lord, apropos your lordship's very correct, my lord, the proposition, my lord, the Chief Justice says at the outset that in every matter we are not supposed to look at 145.3.
But as far as justiciability is concerned, paragraph 155.5, Evam Bibia.
Yes, ma'am. But 155 will have to be read in context of 151,
Yes,
150.
sir, but then even you read 155.5.
Fifthly,
Page 1, 2,
the underlined portion, highlighted part. Fifthly, the submission advanced on behalf of the respondents that the exercise of discretion under Article 163(2) is final and beyond the scope of judicial review cannot be accepted. Firstly, because we have rejected the submission, but this is on judicial review, not on discretion. Rejected advance by the respondent that the scope and extent of discretion vested with the governor has to be ascertained from Article 163(2) on the basis whereof the submission was canvassed. And secondly, any discretion exercised beyond the governor's jurisdictional authority would certainly be subject to judicial review. It was on judicial review. And it is, if it is beyond, but not obviously, if governor.
according to you, under 200, he has an ample discretion.
That's
And
what
therefore-
Nabam Rabia says, my lord. And my lord, that's my contention. He has ample discretion, my lord. Situations may differ. The instances which are given in all the judgments are illustrative, not exhaustive. But they say that it is wrong to say that in every matter, like President, he is bound in every matter by aid and advice of the Council of Ministers. Samshay Singh also, my lord, 7-judge bench says that there are discretionary areas, including Article 200. Specifically, Article 200, every constitution bench mentions. That was precisely, my lord, the question in Tamil Nadu. I'm not, my lord, deviating from this point, but, my lord, just to, my lord, kind of respectfully respond, my lords have very rightly said that in every case, it's not necessary that the court would examine 145(3). A bail petition comes, it would involve Article 21. But it won't become a constitutional interpretation question that it has to be referred to the larger bench. But this was a case where only issue was constitutional interpretation. Facts were not, my lord, much in dispute. Anyway, my lord, leave it at that. Please come to BK Pavitra. My lord, para 66. This is, my lord, declared to be per incurium by the 2-judge bench, my lord, in Tamil Nadu. I'll show, my lord, that. Where a bill is not a money bill, your lordship gets. Where a bill is not a money bill, the governor may return the bill for reconsideration, upon which the House or Houses, as the case may be, will reconsider the desirability of introducing the amendments which the governor has recommended. If the bill is passed again by the House or Houses, as the case may be, the governor cannot thereafter withhold assent. The second proviso to Article 200 stipulates that the governor must not assent to the bill, but necessarily reserve it for the consideration of the president if the bill, upon being enacted, would derogate from the powers of the High Court in a manner that endangers its position under the Constitution. Save and except for bills falling within the description contained in the second proviso, where the governor must reserve the bill for consideration of the president, a discretion is conferred upon the governor to follow one of the courses of action enunciated in substantive part of Article 200, aside from bills which are covered by the second proviso, where the governor is obliged to reserve the bill for consideration of the president. The substantive part of Article 200 does not indicate specifically the circumstances in which the governor may reserve a bill for consideration of the president. The Constitution has entrusted this discretion to the governor. The nature and scope of the discretionary power of the governor to act independent of or contrary to aid and advice of Council of Ministers under Article 163 was discussed in Nabam Rabia versus so-and-so, where, my lord, 154 is quoted. No, I've read, I'll skip that. Then para 67 of BK Pavitra. The framers carefully eschewed defining the circumstances in which the governor may reserve a bill for a consideration of the president. They did not give instances, they left it open-ended. By its very nature, the conferment of power cannot be confined to specific categories. Exigencies may arise in the working of the Constitution which justify a recourse to the power of reserving a bill for the consideration of the president. They cannot be foreseen with the vision of a soothsayer. The power having been conferred upon a constitutional functionary, it is conditioned by the expectation that it would be exercised upon careful reflection and for resolving legitimate concerns in regard to the validity of the legislation. The entrustment of a constitutional discretion to the governor is premised on the trust that the exercise of authority would be governed by constitutional statesmanship. In a federal structure, the conferment of this constitutional discretion is not intended to thwart democratic federalism. The state legislatures represent the popular will to those who elect their representatives. They are the collective embodiment of the will. The act of reserving a bill for assent of the president must be undertaken upon careful reflection, upon a doubt being entertained by the governor about the constitutional legitimacy of the bill which has been passed. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for consideration of the president. Article 254(2) is an illustration of the constitutional authority of the governor to My Lord, Justice Suryakant has the same 5 minutes. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for consideration of the president. Article 254(2) is an illustration of the constitutional authority of the governor to reserve a law enacted by the state legislature for consideration of the president in a specified situation where it is repugnant to an existing law or to a parliamentary legislation on a matter falling in the concurrent list. Eventually, which is specified in Article 254(2), does not exhaust the ambit of the power entrusted to the governor under Article 200 to reserve a bill for consideration of the president. Apart from repugnancy in matters falling in the concurrent list between state and the parliamentary legislation, a governor may have sound constitutional reasons to reserve a bill for consideration of the president, apart from the repugnancy issue. Article 200 in its second proviso mandates that a bill which derogates from the powers of the High Court must be reserved for consideration of the President. Apart from bills which fall within the description set out in the second proviso, the governor may legitimately refer a bill for consideration of the President upon entertaining a legitimate doubt about the validity of the laws. By its very nature, it would not be possible for this court to reflect upon the situations in which the power under Article 200 can be exercised. This was noticed in the judgment of this court in Hext. In Hext, so and so. Lord, I'm sorry, I'm always confused with this pronunciation. Excluding it from judicial scrutiny, the court withheld. My Lord, I have read this, my Lord, when I read Hext, my Lord, so I'll not. Yes, my Lord. I'm not reading it, my lords. Now, your lordships, my lord, kindly come to, my lord, this point is over, my lord. My lord, there are some issues, my lord, which we have divided with a view to save time, my lord. My learned friend also would assist your lordships, would supplement without, my lord, repeating, my lord. They would be able to more and effectively assist your lordships. My lord, kindly come to 204. But,
In a louder manner.
yes, sir.
Both of them.
No, anything remains, not survives.
Survive for you.
Yes, sir.
We'll have to put off the wife.
Yeah, yeah. Oh, this is And there was an interesting incident. I'll not share it here. My Lord Justice Narasimha, me and my colleague, my Lord, we went to Pune for arguing one matter, my Lord. Before NGT Pune, my Lord. But I'll some other day, not in the matter. My Lord, question number, page 204.
Why are you unnecessarily anything about exactly?
No.
Either you should have not mentioned.
Now we have
Or
mentioned
if you have mentioned, you mention it fully.
Yes.
Unless it is not embarrassing to my learned brother.
No. It's not, my Lord, embarrassing to his.
So what happened in NGT Pune?
Lord, I'll just say with his permission.
Not let you proceed out.
No, I'll say that.
You
with
can't
his-
stop halfway.
Lord, I'll say that with permission of my learned friend and with an apology. But it's not intended to insult. Lord, NGT Pune is a small courtroom. It's like a little slightly bigger bedroom. It's in a government building. My learned friend, all of us were on the same side. He was arguing, Lord, in his own way. Justice Kingaonkar.
In his own volume.
Yes. Justice Kingaonkar was presiding over the bench.
Yes.
So at some stage, he did like this. So my learned friend understood that the honorable judge is unable to cope up with my speed. So he continued the same volume. But reduced the speed. Then I requested my learned friend that the trouble is with the volume, not the speed. And the judge complimented me by saying that, thank you, you prevented Punjab Mail. Sorry, but he's like my brother, Lord. I can take this liberty. My lord, my lord, page 204. My lord, this is, my lord, something very, very serious, and your lordships may take this, my lord, into consideration. One constitutional organ prescribing time limits for another constitutional organ. My lord, I can, my lord, I have no quarrel and I will never argue, my lord, and I'll pitch my argument that statutory functionaries can be bound by a time limit. The deputy collector deciding to grant or withhold non-agricultural permission. But would it apply to constitutional functionaries which are coordinate constitutional functionaries? My lord, these are the two questions, my lord, which are question number 5 and question number 7. My lord, I have incorporated, my lord, the debate which I have already read. In one line, I may just refresh your lordship's memory. Wherever time limit was stipulated at the time of drafting of the constitution, the time limit was deleted. And in that very provision, wherever time limit was required, time limit is added. So constitutional framers are very conscious of the fact that some functions need a time-bound exercise of power and some functions needs a kind of leeway, and we may not bind the constitutional functionaries with the power. My lord, please come to page 208, and I'm not going to read this, only for your lordship's assistance at page 209. My lord, I have compiled the constitutional provisions where constitution itself stipulates the time limit. I'm not reading it. Lord, this, just Lord, with a view to see that your lordships gets it, Lord, at one place. Lord, 209, Article 22, Article 62, etc., my lord, the list goes on till at page 224. Wherever the Constitution has thought it appropriate for the object which that particular provision seeks to achieve, the Constitution provides for a time limit. Wherever the Constitution has, framers have considered. Yes, my lord, kindly note one more thing. Tamil Nadu judgment, which mandatorily stipulate time limits for the Honorable President and the Honorable Governor, relies upon the report of Punchi Commission and Sarkaria Commission. It itself says at the end, and obviously so, that these are our recommendations and we recommend suitable constitutional amendments. Meaning thereby, the reliance on the report itself, my lord, in my respectful submission, may not be correct, because Commission does not say that do it by way of a judicial adjudication. It has to be, my lord, logically. I don't have to stretch this point any further. If a commission is appointed by the central government of the day will consider whether to bring it by way of an amendment or not. But very interestingly, my lord, a converse situation has arisen. My lord, in one judgment, which your lordships would find at page 231, where one organ of the state, namely the legislature, provided for the time limit for another organ of the state, namely the judiciary. And matter went before, my lord, 7 judges bench. And your lordships would find the judgment at page 231.
238.
231.
Paragraph 2.
Lord,